believe it or not, I can't fit all the pleadings in one binder. Is everybody here that needs to be here for us to get started? I know I got to put a robe on, but other than that, you guys, plaintiffs ready? Defense? Okay. Mr. Trudell, hello again.
Hello,
You ready to go if I get a robe on and I call the court to order?
all set.
All right, I'll be right back. All right, good morning.
Morning.
Now, you all know I was a trial judge and a trial lawyer. When you said good morning to the veneer, and that was the response, you knew it was going to be a tough morning to pick a jury. So we'll try that again. Good morning.
Good morning.
The Court of Claims of the State of Michigan is called to session. My name is James Robert Redford. It continues to be my privilege to serve the plaintiffs and defendants in this case and to serve on this case. Today is May 5th, 2025. The time is 9:58. We've had a number of pleadings have been and orders have gone out about today. The one thing, so I don't forget, we have a hard stop at 1:30, not because of me, but because another judicial officer has another case that requires the use of this courtroom for the Court of Claims. So Judge Yates has some hearings, and in the event that we still need to conduct further discussions, because the order of march, as my Army judge friends used to say, is going to be the 30 minutes each side for the summary disposition motions and the replies and responses. And then we're going to move into the status conference aspect of things. I do not think we'll be here till beyond 1:30, but I'm available all day. But what we will do is we'll go into basically what would be if I was the circuit judge. So we do everything in camera from that point. And Mrs. Tomlin has been kind enough to reserve the third floor conference room that a number of us have been in previously in this case. You know, takes a few different elevators to get there, but that would be my general plan. I don't think it's going to be necessary, but if we need to keep going, we'll keep going until we don't have to keep going. Okay. All right. So we're here in Grand Rapids. Thanks for being here. It's time and date the court ordered for oral arguments. If I could have appearances before we start the oral arguments on the motions, that'd be great. From plaintiff's side, who do we have, please?
Carlson for plaintiffs.
Yeah, I'm for plaintiffs.
David Dugan here for the plaintiffs.
Jason Thompson for the plaintiffs.
Elizabeth Bacon for the plaintiffs. Alderman Kennedy for the plaintiffs.
I'm sorry, one more time, ma'am.
Alderman Kennedy.
Kennedy. I wasn't sure whether it's a hyphenated or, so, okay. All right. Thank you, counsel for the plaintiffs. Defense.
Maybe Gamble here for the defendants, Your Honor.
Good morning, Your Honor. Richard Cole for defendants.
All right. Okay, let me, before we get started, turn. All right. My understanding is the manner in which we're going to proceed is the first order of business will be the oral arguments on the motions that have been filed. I've read all the briefs. I thank both sides counsel. I will not sit here and say I've read every page of every exhibit. That I'm not sure that would be a statement that would require me going to confession, but it would not be accurate. I'm just not sure if it'd be a venial or a cardinal sin to say such a thing. So I haven't read everything because there's 2,400 and I think 57 pages of documents, somewhere in that ballpark. And I didn't read all of them. I read some. I read every brief. I read a lot of the cases that are relied on in the briefs. Appreciate the advocacy on behalf of both parties. My understanding is this is the defense's motion, so they're going to go first. 30 minutes. If you want to reserve any time for rebuttal, just let me know. Jump straight how much you want to reserve. We'll then go to the plaintiffs for their reply argument or responsive argument if they choose to have any, and then we'll see where we're at. And then following that, we'll move into our status conference. I did have a chance to review a lot of the issues. Well, I've read all the status conference submissions. I will say, as relates to the status conference, while your sister and brother counsel are presenting argument to the court, if those who are not presenting argument would look at their calendars for these 6 dates. They're all in May. 20th, 21st, and 22nd. 27th, 28th, and 29th. The reason I want you to look at those days is it sounds from some of the submissions that there are some ongoing issues related to expert discovery. If the attorneys do not come up with a plan that is mutually satisfactory to both sides, the court is going to order that the lawyers and any expert witnesses who need to be deposed be in this building those 6 days with a court reporter to complete all expert discovery. I have made my calendar available such that if there are disputes, which there shouldn't be, but if there are, we will be coming in here on the record. Whoever the court reporter is will have to be present. It is my understanding the Attorney General's office has an office in this building. Is that correct?
I believe so, if not nearby.
Okay. Since the Attorney Generals have an office they can use as their litigation room, the court is asking my staff to find a suitable spot and a suitable space for the plaintiffs to have a similar home base during those 6 days, if that becomes necessary. It is my hope that the lawyers are going to be able to work out all these issues and we won't have to do that. But hope without a plan is just a dream. So I have a plan. We don't need to talk about it now, but I'm putting that out there so that whoever's presenting the position for the people, the defendants, that co-counsel can think about what I've said. And then whoever is presenting for the plaintiffs, the other 6 co-counsel can think about what I've said. I don't propose to have all the answers. but I do know what the answers need to be. And that is the completion of the discovery process in this case. And I hope to be able to proceed in that way. Before we start the oral arguments, and since this is the defense's motion, I'll ask defense first. Is there anything else we need to address?
No.
Okay, plaintiffs, anything we need to address before we start? Okay, all right. And as you see, we now have microphones at our table, just like a regular courtroom. So, but you will be, unless otherwise, I assume if you have substantial comments, you'll be making them from the council table or from the podium. So, all right.
Thank you, Your
Gamble.
Honor.
Thank you.
Nathan Gamble here on behalf of the defendants, Michigan Department of Natural Resources, the Michigan Department of Environment, Great Lakes, and Energy. May it please the court.
Thank you.
I'd
Let me
like to,
just check the time. Okay, we're starting at 10:06.
all right, I anticipate reserving maybe 10 minutes or so for
All
rebuttal,
right,
Your
so
Honor.
you know what? Hold on just a moment. Everybody stay in place. I'm gonna get my phone so I can keep track of time. All right. Please proceed when you're ready.
Thank you, Your Honor. Your Honor, to introduce why we're here today, the state agencies did not condemn the plaintiff's property. These state agencies did not take the plaintiff's properties for a public use, but that does not mean that the plaintiff's property was not damaged. This was a major disaster, and the state government recognizes that, the federal government recognizes that. Between state and federal grants and payouts from insurance companies, somewhere around $400 million has been invested into the community to help it recover from this major disaster. And the reason I preface my comments, Your Honor, is just to clarify, and I think the court obviously is aware of this, but we're not here about whether the plaintiffs have experienced damages. That's not the issue that we're talking about. So when I say that the plaintiffs do not have evidence to support their claims, I'm talking about that they do not have evidence to support their claim that the state agencies are responsible for the damages they experience. Damages are a separate issue. And there has really been a lot of incorrect information circulating about the Edenville Dam and the broader media ecosystem here in this case. I really think it would be beneficial for me to take a few minutes and just run through the history of the state's regulation, the federal regulation of this dam, and highlight the facts that are supported by actual evidence that are now in the record in this case. So to support their legal claim, the plaintiffs need to show that the state agencies abused their authority, took affirmative actions that were directly aimed at their property that substantially caused their property to be damaged.
Can they sustain their burden by non-actions or negligence?
No,
So took affirmative actions directed against property.
that substantially caused damage. So the failure to act cannot support an inverse condemnation claim. There's no law anywhere that I'm aware of that holds otherwise, nor can merely negligent action support a takings claim.
Negligence is a tort.
Yes. So plaintiffs argue that the Edenville Dam failed because the level of Wixom Lake was maintained at its normal level. Now, I don't think that that's necessarily true, but it really doesn't matter because the state agencies here are not the ones who determine the level of Wixom Lake. This was a private dam surrounded by a fence, run by a small privately owned business, family business, and the state agencies had no control over how these private people operated their dam. They did not go in there and work the controls or anything like that. And Wixom Lake had been maintained at its normal level for decades prior to falling under state jurisdiction. That level was adopted into a federal license that was issued decades ago. And Wixom Lake had been maintained at that level during the entire time it was under federal jurisdiction. And while it was under federal jurisdiction, the Federal Energy Regulatory Commission, and consistent with their guidelines and laws, that dam was inspected every year by a FERC inspector. And then every 5 years, it was inspected by an independent consultant who would do a very thorough analysis of the dam, more thorough than the annual
2018,
inspections.
the FERC license is revoked, correct?
Yes.
Okay.
So in 2018, the FERC license is revoked. And at that time, this is what those inspection reports had shown. The inspection reports had shown that, yes, the dam had insufficient spillway capacity to meet federal standards. That was widely known, widely understood the entire time it was under FERC jurisdiction. Those inspection reports also said that the embankments are in good condition and that there is no sign of a developing failure of the embankment. And they also said, as the 2015 independent consultant said, that, quote, the project and its facilities are suitable for continued safe and reliable operation, close quote.
On September 13th, 2018, did Lee Mueller seek to communicate with Luke Trumbull, an employee of the state of Michigan?
Yes,
Okay. Did Mr. Trumbull reply?
I think so, yes.
Are there emails that are that in the plaintiff's March 7th, 2025 pleading, which you've had a chance to review?
Yes, Your Honor, yes.
Okay. Did Mr. Mueller send emails that included the language which is included in the plaintiff's brief?
I'm not sure, Your Honor, which language you're referring to.
Okay.
I don't mean to be
Nope.
difficult. I just don't know.
That's why I'm on the binders. Hold on. At page 5 through 7 of plaintiff's March 7th, 2025 reply to your brief, there's a statement attributed to Mr. Mueller that says, apparently I did not adequately express a sense of urgency that should be applied to scheduling MDEQ Dam Safety Division's inspection of the Edenville Dam. FERC's license termination order will clearly place the dam spillways under an exponential increase in wear and tear and already deteriorated concrete rollaway slabs by requiring all water discharges to be passed through the spillways. Parenthetically, my understanding is that's because when it's not producing hydroelectric power, all the water is going through something other than the turbines. Is that a correct understanding?
Yes,
It continues, this is the water flow that must necessarily pass through the dam if the turbines are taken out of service. While the Edenville Dam is not equivalent to the scale and potential hazards of the Oroville Dam, a similar catastrophic event of spillway failure, parentheses of a smaller magnitude, close parentheses, will undoubtedly result if constant flow through the radial Tantor gate spillways is instituted in the near future. Did he send that?
yes, the email, Your Honor?
Yeah.
Yes,
What's Mr. Trumbull's job?
he's the dam safety engineer for Eagle.
Okay, so what, if anything, is the significance of that email as relates to what the state did, didn't do, shouldn't have done?
The significance of the email is that Mr. Mueller was in the process of trying to persuade the Federal Energy Regulatory Commission that it should not revoke his license because they issued the order on September 10th. And this email is September 13th, and it was going to go into effect on September 25th. So he's trying to get Eagle to tell FERC not to drop the license, to let him keep his license. And so it
What was the state? Okay. was the state aware that when FERC revoked the license, they had concluded that the operator had knowingly and willfully refused to comply with major aspects of its license with public safety put at risk?
Yes. If I may, Your Honor.
Yeah.
That's the importance of pointing out these inspections reports because they identify the deficiencies Mr. Mueller is referring to in terms of the lack of spillway capacity. That does not mean that the lake level should be modified. Not one of those inspection reports ever said that because the spillway capacity was not sufficient, the lake level should be modified. Instead, it said the opposite.
Okay. Prior to May 19th, 2020, if somebody wanted to let as much water as is possible in a controlled manner out of the what is called Wixom Lake, but what is in reality a dammed up river, right?
Yes, it's an impoundment, Your Honor.
Oh, impoundment, thank you. How low could someone have lowered that lake?
If you look at the brief, the defendant's brief, we pasted a picture of how low the lake gets in that circumstance. And it is on,
Page.
pardon me, let me find it.
This is assuming that the Lord will be merciful and I'll be able to open up this document. But
This is on page 16 of the defendant's brief.
I'm on page 1,103 of your brief so far. So let me go back out. What page 6 you said?
16.
Okay.
So that graph shows the level of Wixom Lake when the gates are fully opened. Oh, I'm sorry, Your Honor.
It's just, I'm just not very good at technology. Okay. So this is one where the narrative below it says, even though Boyce Hydro.
Yes.
Okay, so,
So about,
all right, so here's my,
sorry.
you all have had to suffer through me being the judge assigned to this case for a year and a half now. So you've heard me tell all sorts of stories. As a young man and as a boy, I canoed the Ausable River system from the upper reaches immediately below Lake St. Helen, which are the headwaters of the South Branch, eventually all the way to Lake Huron. There are 5 or so old dams, TVA era dams on that waterway. On that waterway, on one occasion, I floated between either Loudon and Alcona Dam down to Cook or Foote, but somewhere downstream from Mayo. We camp on the side of the river. I might add in an unauthorized camping spot, but I'm sure the statute of limitations is run on that violation of the laws of our fair state. We put our canoe on the side of the river, camp. We get up the next morning. The river that was there is completely gone. It's reverted entirely to the initial natural flow of the river at that time. And this is in the either 1970s or 1980s. My point is they needed to do repair work on one of the dams. Apparently it was whatever utility owned it, either the dam downstream or the dam upstream. To facilitate that, they lowered the water that much. Would that have been possible to do in the Edenville Dam.
Not the extent that you're describing,
Okay.
no. That was physically impossible.
All right. So the lowest it can get is where you're at on here, and that's 6.
Yeah, about 600, about 670. Yeah. So that accounts for
Okay.
about a little over 2 feet of water still flowing over the spillway because this is an impoundment on 2 rivers. So these 2 rivers are still flowing into it. The water has to go somewhere. So even when it was lowered, it's still creating an impoundment. And no one had ever,
How many cubic feet per second correlate to every inch of increased water level in the dam, if you know?
I don't know, Your Honor. It would be a guess. And so I don't want to guess. But at the point that the license was revoked, the actual order revoking the license said nothing about water levels. It didn't warn that it was somehow dangerous to maintain the normal level of Wixom Lake. It didn't recommend altering those levels at all. And on the very day that the license revocation went into effect on September 25th, Lee Moeller, the owner of Boise Hydro, he emailed the county's task force and asking them for money, saying, if you can pay me, I can keep paying my staff to maintain the normal level. He didn't say it's dangerous to maintain the normal level in spring flooding conditions. He didn't say anything like that at all. He said, because the federal government just revoked my license, I don't have income anymore, so I can't pay
Right.
my staff. I got to lay them off. So the county did the wise thing. They didn't just jump to it right away, Your Honor. They hired an engineering firm to answer the exact question: what level should we set Wixom Lake at? Now that the license is gone and the flows are not going through the powerhouse anymore, like you noted, Your Honor, they had an outside independent engineering firm look at this.
Those Spicers.
Spicer Group. Spicer Group looked at it and issued a report that said, we recommend you continue to maintain the normal level. Doing that is not going to harm private property. That's what you should do. And so the county's task force said, okay. And they found the money. They paid Mr. Mueller, and he funded his staff to go and maintain the normal level of Wixom Lake. That was what happened. And then they obtained a court order, the counties did, to establish that normal level consistent with the recommendation of the Spicer Group. And then they entered into a contract with Boise Hydro saying, we want you to keep maintaining this normal level. We'll keep paying you to do it. And that's what happened. That's why the level of Wixom Lake was continued to maintain its normal level. They only did it after an engineering firm told them it would be okay to do. And the state agencies were not involved in that process. They have they have 1,200 other dams under Eagle's jurisdiction. Anytime a lake level proceeding is commenced anywhere in the state, Eagle will review it and appear and comment on it in some way. That's the extent of their involvement with setting the lake level for Wixom Lake. They said, okay, we don't have an objection to this. Just pretty consistent with what they do in pretty much every other lake level proceeding. So that's why the lake was set at the normal level. And we have to ask ourselves, Your Honor, what if FERC had not revoked its jurisdiction? What if Boise Hydro still had a hydro license? What would the level of Wixom Lake been at in May of 2020? It would have been at its normal level. There's nothing about the agency's involvement here that somehow changed what would have happened had FERC never revoked the license.
Do you know Teresa Seidel?
Yes,
All right, so she's the director of the water division, I think, right?
she was, Your Honor. Yes,
Okay, retired now.
just different job.
Okay, all right. Did she author an email on November 13th, 2019, that in the fall of 2018, the state knew that the dam likely did not have half of the probable maximum flood capacity?
Yes,
How, is that of any moment?
no,
Why?
because just because a dam does not have sufficient spillway capacity does not mean that you have to lower the impoundment. That's what the Spicer Group report concludes. That Spicer Group report says we need to do construction work on this dam. Its spillway capacity isn't sufficient. Here's a construction plan and how much it will cost. In the meantime, maintaining the normal level will not cause damage to private property. And so the county's task force pursued that path. There was no warning from any engineer at any point that said that because the spillway capacity is insufficient on this dam, you have to modify the normal level. No one said that.
Do you agree that MCL 324.31506 sub 1 gives the state the authority to control the dam?
I'm sorry, could you say the citation one more time?
324.31506 subparagraph 1.
I have to look at that specific. I can tell you that part 315 gives the state or the Eagle, Department of Environment, Great Lakes and Energy, authority to regulate dams that are not regulated by FERC. And so once this dam was not, and so yes, that just to answer your question, yes, of course, Eagle had regulatory authority over the Edenville Dam once FERC revoked its jurisdiction. And it had the authority, and I don't know if this is what you're getting at, Your Honor, possibly, but it had the authority to issue orders under 31519, which is what the plaintiffs really emphasize and focus on, to modify the levels of a dam, or excuse me, of an impoundment. But in order to use that authority, there had to be some reason for it. And as I said, the existing engineering reports at that time said that the dam was suitable for continued safe and reliable operation.
This expert says it wasn't. It says it was dangerous and all the other things that individual says.
Well, that individual's perspective looking backwards with the benefit of hindsight is different than the information that was available at the time and the recommendations existing at the time.
Right. That's your position. I understand that, and maybe ultimately meritorious. But at this point, the evidence has to be taken, obviously, as all the lawyers sitting in this room know, in the light most favorable to the non-moving party, assuming the inferences and both direct and circumstantial in favor of the non-moving party. There's an affidavit of record. There's deposition testimony of record, which takes a contrary position to that which you are taking.
That, Your Honor, respectfully, there is no genuine issue of material fact here. And that's my 20 minutes, I think. So I'll,
20 minutes.
okay, I'll reserve the remainder of my time. Thank you.
Thank you. See if I can turn that time alarm off and get one set for. You may proceed, counsel.
Thank you, Your Honor.
Just want to identify yourself for a court reporter. That'd be great.
Of course. Good morning, Kevin Carlson, on behalf of the plaintiffs. I'm one of the mass tort plaintiffs counsel, Your Honor.
Why do we have mass tort since this is not a tort action?
A bit of a misnomer, perhaps mass constitutional tort in this
It's
context.
not a constitutional tort. It's a taking. It's not a tort at all.
But the private right of action, I suppose, could be characterized as a tort.
Okay.
We can talk about that some other time. Okay. Good morning, Your Honor. Kevin Carlson appearing on behalf of the plaintiffs. I intend to use as much time as you allowed this morning for oral argument. Mr. Thompson and Mr. Dubin are here in case the class attorneys have to add anything different from what I, as one of the mass.
Well, they're not going to be able to add anything if you use the 30 minutes.
All right. I'll be respectful of that. Thank you.
It's entirely up to you. I don't want to be in the lunch group afterwards if you don't.
Your Honor, in Michigan, under Michigan law and as a matter of statute 324.315, there is a clear, objective, and mandatory standard for when a dam is deemed to be safe, structurally sound, and hydrologically adequate to safely contain and hold back the water in the reservoir behind it.
Hold on just a minute, please. Go ahead.
So in Michigan, for a dam to be safe, structurally sound, and hydrologically adequate, it has to be in compliance with MCL 324.315. It has to be. The language in the statute is mandatory. It says shall. And the key objective measure of whether a dam in Michigan is safe, structurally sound, and hydrologically adequate is whether the spillway capacity of the dam is sufficient to attenuate 1/2 of the probable maximum flood, 1/2 PMF. And according to Mario Fusco, who is the dam safety engineering supervisor in this case, whose deposition was taken, by the way, after the briefing here was completed, along with some other depositions that were still yet to be completed at the time of this briefing. He testified, that's why the requirements exist to test safety, structural soundness, and hydrological adequacy. Once a dam fails or is known not to meet the 1/2 PMF standard, it is under Michigan law unsafe, structurally unsound, and hydrologically inadequate. And the affirmative act that the state took here after learning that the dam was, according to its own standard, unsafe, structurally unsound, and hydrologically inadequate, was the affirmative act of authorizing refilling Wixom Lake to its quote-unquote normal water elevation level, which under the circumstances.
It's a body of case law that suggests the granting of a permit is not an affirmative act.
Right, Your
How
Honor.
do you square that with the facts of your case, counsel?
Yeah, the Court of Appeals has already resolved that question in this case. It took the permitting cases, Marilyn Froling, Wiggins, Ankerson, Hinojosa, and said this case is fundamentally different. And the roadmap, we think, for deciding
Let's
them,
say that those cases are not still the law of Michigan.
no, but it said the act of authorizing higher water levels in this case was materially different from the granting of a permit in those cases where permits were deemed
What
to be
page in the
inadequate.
opinion are you citing?
Page 184 to 185.
Hold on, please. All right, go ahead.
Your Honor, after distinguishing Ankerson, Hinojosa, and Marilyn Froling, the Court of Appeals held that plaintiff's allegations in this case established a constitutional taking, and it said, quote, plaintiff's allegations demonstrate more than mere regulatory actions, such as issuing or denying a permit or failing to abate a nuisance. Rather, plaintiff's allegations show active steps by defendants to authorize higher lake levels and to conceal critical information about the risk that the dam's condition posed to specific properties in the surrounding area. Put differently, plaintiffs allege that defendants' affirmative actions set into motion the destructive forces that caused the dam failure and the damage to plaintiffs' properties that were in the direct line of harm. And so Now, the question really is whether those allegations, which are distinguishable from the permit line of cases that Your Honor was talking about, in this case, is whether the facts established through discovery demonstrate that the state of Michigan did in fact know about dam safety problems with the Edenville Dam and did in fact authorize a higher water level with knowledge of that danger. And so with regard to the first sufficient allegation, defendants knew about the Edenville's dam's inability to withstand significant rainfall because of insufficient spillway capacity. Your Honor, the evidence of that is definitively established in a couple pieces of evidence. First and foremost, FERC revoked the license stating, quote, 13 years after acquiring the license, the licensee still has not increased spillway capacity, leaving the project in danger. The spillway capacity deficiencies must be remedied in order to protect life, limb, and property.
What lake level would have prevented this? How many feet and how many inches?
So what we know now from the modeling, Your Honor, is that at 670, the water level would not have tipped over the threshold point, the conservatively estimated threshold point where static liquefaction was likely to be triggered. There's some background as to why that number comes to mind. The historical records, and I know Mr. Gamble cited to a graph at, I believe, page 16 of his brief.
15, but whatever.
Sorry, 15. But there's also a letter written from Boyce's counsel to Eagle stating that that Boyce was running the water level at its determination of run-of-river, which is approximately 669 feet. There is also evidence relied upon by the experts saying that the actual run-of-river level might have been lower than that, lower than 669, maybe even lower than 668. And when Mr. Trumbull, the dam safety engineer, was deposed in this matter, he said it would have been impossible to take the run-of-river level down below 670. That's disproven by the state's own graph, which shows the water level under 670 and closer to 669. But in any event, our expert, Dr. Williams, reran the model, assuming that the water level would have started at 670 run-of-river when the storm occurred. And that resulted in an elevation of the pond to like 680.1, which is still under the threshold for the static liquefaction to occur.
I have a number of questions for you. Who prior to May 19th, 2020 warned of liquefaction as a potential hazard?
Liquefaction was warned of as one of the potential failure modes in the FERC documents, I believe the 2015 and possibly the 2018 independent
What page?
reports. I don't have the page number.
I'd like your co-counsel to find it before we're done.
Yeah, Mr. Dubin should be able
All
to
right.
get that for us, Your Honor.
Do you agree that the state did not have the authority to go onto the property without a court order?
Without a court order?
Yes.
Under emergency circumstances, I believe they could do it without a court order.
Is there any pleading in which the state of Michigan sought to raise or maintain the lake level between 2018 and May 19th, 2020?
Yes, Your Honor. April 9th, 2020, the state authorizes the raising of the water level back to its quote-unquote normal summer lake level. I believe that's our Exhibit
If you don't
45.
understand the question. Did the state file any pleading in any court of competent jurisdiction seeking to have a judicial order that the lake be maintained at whatever level they were asking?
In a pleading, no.
Okay.
No, but they authorized it pursuant to their
I-
process.
Okay, that's not my question. Did the state ever file any pleadings to raise the lake level?
Not directly, Your Honor, but they filed pleadings to punish and sanction Boyce for lowering the lake level.
When were those filed?
December of 2019. And it was May of 2020. April 2020. So
And that was to complaints filed by state to,
seek damages from Boyce as a result of natural resource damage that occurred when the lake level was lowered without authorization.
I believe you allege that the defendants prohibited Boyce from performing needed repairs to Edenville Dam. Is that right?
That's correct, Your Honor.
What repairs? When were they requested? When did the state deny? How did the state deny?
The drawdowns to inspect and repair the dam were requested in, I believe, September of 2019 and November of
In that
2019.
application, the operator sought to do a winter drawdown, and didn't the operator affirmatively represent in that application they intended it to be simply a winter drawdown, and in the spring, they would raise it back up?
Yeah, the intention at the time would have been to raise it back up.
And that's what they actually said, right?
Yeah, correct,
And the state,
correct.
and in fact, Boyce did do a winter drawdown,
They did,
even without the permit.
they did.
And they, just like they said they were going to, they put it back to whatever the flow of the river was that they thought.
Correct, only after going back to the state for authorization to do that.
When did the state issue an authorization to do that?
April 9th, 2020.
Did the Four Lakes Task Force maintain in submissions either to a court or to an agency of the state that it would be safe to maintain the lakes at their historical levels?
At some point, they may have, but by the end of 2019, they had definitely changed their position.
How is that memorialized?
It's memorialized in the September 18th, 2019 email from, I believe, Ted Champagne, who is the Spicer Group engineer.
What's the date again, please?
September 18th, 2019. And he writes to Dam Safety Engineer Trumbull, quote, "The Four Lakes Task Force does not believe that the Edenville Dam can be operated to meet the Eagle Dam safety requirement to pass the 1/2 PMF without certain repairs and improvements," end quote. That's Plaintiff's Exhibit 53, which is page 105 of Exhibit Volume 4.
Okay. To survive summary disposition, do you need to show that the defendants knew that granting Boyce Hydro's permit application would cause the dam to fail?
That they knew it would cause the dam to fail specifically? No, I think they have to know it was likely to cause a dangerous condition, make a dangerous condition even worse. And they certainly did know that. I mean, they knew as a matter of law that the dam did not meet the 1/2 spillway capacity, which means as a matter of Michigan law, it's not structurally sound.
If they're provided a report from an independent engineering company that says it is structurally sound, why can't they rely on that?
Your Honor, the independent forensics team report came out after the dam failed.
I'm talking about the Spicer Group report before the fall of 2019.
Right. That Spicer Group report states that the dam is in poor condition. And the Spicer Group engineers who were responsible for that report, as time goes on and their familiarity and knowledge with the dam develop, they're in direct communication with Eagle dam safety personnel, most notably Mr. Trumbull, telling him that we've now determined basically definitively that the dam can't pass 1/2 PMF, which is what Mr. Trumbull confirms on his own in January 2020. So
Okay, so somebody determined that it could process 28,000 cubic feet per second, which is 30,000 cubic feet per second would have been 50%. So they're 2,000 cubic feet per second below what it needs to be.
Mhm.
Is that standing alone enough to show a constitutional taking?
when they refilled the water level with that knowledge, yes.
Even though this earthen dam has been there for over 100 years at that point,
Yeah.
or close to 100 years,
Yeah.
and never been a problem. No one suggested liquefaction is going to happen tomorrow. Anything remotely close to that.
Yeah.
Okay.
Yeah, that's correct. But that level of specificity is not the standard. And the red flags that occurred in the last 5 years of this dam's lifespan were so severe that, in the words of our dam safety expert, it was dam safety 101 not to refill the reservoir level. I mean, things like the steepness of the embankment, the fact that there are berms on one side but not the side that failed, the fact that the piezometer readings show that the soil in this dam is very responsive to fluctuations in water level, which show that it's very susceptible to soil instability. In addition to the lack of spillway capacity and shutting down the turbines, which means the dam can't pass as much water as it used to.
Are you familiar with the opinions issued by judges Maloney, Luddington, Sutton, McKeague, and Bush?
Yes, Your Honor.
Why are all of them wrong?
They're wrong for the reasons cited in our brief, Your Honor, that I believe the page.
This is your brief now, counsel?
Yeah,
Okay,
correct.
tell me.
I can find the page, Your Honor. They rely exclusively on the IFT report, Your Honor. And our expert, Mr. Sturdivant, attacks the IFT report directly, calling a lot of its assumptions and conclusions into question. First and foremost, the modeling used to reach the conclusion in the IFT report that an elevated water level in the lake prior to the flood wouldn't have made a difference, was based on incorrect characteristics because it included 3 feet of water as a starting point over the spillway, which is not where the water should have been and wasn't realistic given the condition of the dam and the infrastructure at the dam. And then at pages, just to refer you to, at page 44 and 45, we go through our experts' criticism.
I'm sorry, counsel. 44 and 45.
44 and 45, Your Honor. We go through our experts' criticism of the reasoning of the Bruneau Court in the Sixth Circuit, which affirmed Judge Luddington, I believe, including, as I just stated, the IFT analysts had the water level starting too high in their model. IFT assumed a free flow of water through the spillway gates.
Let me up just a second, please.
Mhm.
Are we talking about your March 7th, 2025 pleading?
I'm talking about the corrected brief that was filed on April 19th. It should, the page numbers should be about the same. We didn't,
Don't think they are.
they're not, okay.
At least
Sorry.
not what I.
It should be in the
Here,
ballpark.
here I thought I was ready for today
Sorry.
after spending the weekend in chambers and reading. And reading and reading. And it may be, I'm just operator error on my part, and I'm not trying to be, not trying to be funny. Judges trying to be funny is usually not very judicious, so I'm not trying to be funny. Okay. So your position, did Judges Ludington and Maloney have the benefit of the expert upon whom you're relying in this litigation?
No. No, nor did they have any, I believe in the Ludington case, which really, where the causation of the failure was at issue and the IFT report was at issue, Judge Ludington and the parties in that case did not have the benefit of any experts, such as we have in this case.
Right. Let's continue. Well, let me ask you, under Mays and Krieger, do you have to demonstrate that the defendants concealed the truth of, and that the concealing resulted in damage to property?
No, Your Honor, that concealment would be an additional plus factor, affirmative act, but it's not an essential element of the case.
How, if your position is correct, okay?
Mm.
How does that standard, that legal standard, not essentially convert a constitutional taking into negligence, which we know it can't?
Without concealment,
Right.
because you still have to show an affirmative act. And the affirmative act in this case was authorizing the higher water level, just as the affirmative act in Mays was authorizing the switch in water sources.
But in Mays, it was a state, Mays involved, as the case clearly states, the state of Michigan, through the Emergency Manager Act, appointing a city manager, or that's not the right word, but I'm sorry, appointing an emergency manager. The Karagandhi, and I'm probably mispronouncing that, water resource project became something that was moving forward, and a decision was made to switch from what is now the Great Lakes water system, but what that then was the Detroit water system, to Karagandhi. Upon switching, 1 year notice was given to the city of Flint, said, in my understanding, you're no longer going to get your water from us. And then a year later, they converted to the city of Flint's water system. But the individuals who were in the senior leadership, it was the court, I think, found, were state actors.
Mhm.
When they made that decision to switch to Flint water, and that, I believe Judge Boonstra, sitting as a judge of the Court of Claims, and then subsequently the Court of Appeals, and I believe the Supreme Court, said that that's enough of a state action, but it was affirmative acts by a state actor. In this case, there's no allegation that I'm aware of that the dam which failed was owned, operated, or controlled directly by state of Michigan actors. Is that fair?
I don't think it's fair as it applies
Okay.
to this case or to Mays, Your Honor. I went back,
Okay.
I went back, I read the Court of Appeals opinion in Mays, I read the Supreme Court opinion in Mays, I read the Krieger opinion in this case, which applies Mays, to try to make sense of this argument that our opponents made in their reply brief, that the necessary element that was present in Mays but not present in our case was a unification of who the state actors were.
Control, if you will.
Of control.
Okay.
And the Mays opinion says, it doesn't say that the unification of state actors between the city defendants and the state defendants is what, triggered liability. It says the opposite, because the state defendants in Mays distinguished themselves from the city defendants. The state defendants in Mays said this was the city defendants' decision to switch the water level. And the Court of Appeals and the Michigan Supreme Court said that at this stage of the proceedings, it was the state defendants' authorization of the city defendants to use the Flint River as an interim water source, while both sets of defendants knew that using the river could result in harm to property that constituted the affirmative act. And so
What page are you on?
this is page 175 of the Michigan Supreme Court
Oh.
decision in Mays, and it's page one.
Let me catch up with you. Hold on.
Yeah, sorry.
It's all right. Okay.
And it's page 185 of the Krieger decision, quoting page 175 of Mays. And so just like they do in this case, Your Honor, in Mays, quote, the state defendants argue that if there were an affirmative act that was directed at the plaintiff's property, it was the city defendants who effectuated the act, not the state defendants, end quote. So for our material purposes here, that's the exact same defense that's been raised and incidentally rejected by the Michigan Court of Appeals in this case. The Michigan Court of Appeals knew when it issued its published opinion in our case that Boyce was the private owner of the Edenville Dam and not in and of itself a state actor. And it also knew that the state Eagle had authorized the water level increase and held that that was legally sufficient to be an affirmative act.
Counsel, in Mays, it says where you're talking, quote, the state defendants argue that if there were an affirmative act that was directed at the plaintiff's property, it was the city defendants who effectuated the act, not the state defendants. While discovery may bear evidence that supports this conclusion at this stage of proceedings, we must accept all of plaintiff's allegations as true. If true, plaintiff's allegations are sufficient to conclude that state defendants abused their powers and took affirmative actions directly aimed at plaintiff's property.
Right. And what we've proven true in this case is that the state did exactly that. They authorized the higher water level on April 9th, 2020. After determining in January and February of 2020
On
that
April
under
9th, 2020?
April 9 of 2020, our state defendant authorizes the higher water level. They had known for at least 2.5, 3 months, if not for a full year, that this dam by its own standards was structurally unsound.
You're referring to by the state's own standards.
By the state's own standards, right? And, our opponent, and I know I'm out of time, make this one last point. My opponent says no engineer ever told us that the dam was structurally unsound. The 3 Eagle Dam safety engineers who are most intimately involved, hands-on involvement, to the point where they know what kinds of tools are being used to try to pry these gates open and how far the gates can open and not open and where the water level should be. Trumbull, Pulowski, and Fusco, they know definitively that this dam does not meet the minimum standards for safety in Michigan. And then they authorized the higher water level despite that knowledge. And that's our allegation of an abuse of authority that the Court of Appeals has already deemed sufficiently analogous to Mays for us to get past summary judgment here.
Thank you.
Well, Your Honor, did you want me to get the page citations to the FERC 2015 from Mr. Dubin? It was referred to earlier in the argument.
Okay, yeah, we can, when we're doing the status conference.
Okay.
Since brother counsel went a little over, I'm adding 3 minutes to your time.
Thank you, Your Honor.
Please proceed.
Nathan Gamble on behalf of the defendants, Your Honor. First, just to go through and clarify some of the matters. First of all, I never said, and we've never argued, that no engineering report said that the dam did not have sufficient, or that the dam did not have sufficient spillway capacity. That was demonstrated by many engineering reports. What we've argued is that those reports held that the dam could still safely operate. And that's different. So at the time that Eagle granted the permit application in April 2020, there was no report saying this is a dangerous thing to do.
I'm sorry, when Eagle did what, April 8th, 2020?
Eagle granted, Boyce Hydro and the county's task force filed a permit application to return Wixom Lake to its normal level, and Eagle granted that application in April 2020. At no point at that time had there been any engineering report that said this was a dangerous thing to do.
What do you make of council's position that the Spicer Group originally said things are good to go, but they subsequently said he hasn't. Let me just also comment. I just saw on the screen somebody raise their hand. The order of march, as I said previously, was if you wanted to speak to the court, you needed to be in the courtroom. So I'm not sure who that person was. I apologize that we're not able to facilitate that individual's participation, but that's why I'm not going to be seeking out and asking for comments. So anyway, so if somebody wants to, if you're a plaintiff's counsel or a defense counsel, if you want to text your friend, that was great. Oh, okay. Somebody just said, I raised it in error. Now that would be me, actually. So now I got to add 2 more minutes because of my soliloquy about hand raising on Zoom calls. So, all right.
Thank you, Your Honor.
Please go ahead.
The Spicer Group did not change their position about the normal level of Wixom Lake. They are the ones who submitted the permit application. That's in the record, Your Honor. It's the Spicer Group who asked to return it to the normal level. They didn't change their position.
So Mr. Carlson's just wrong?
Yes, he's wrong. And so what the Spicer Group wanted was to temporarily lower Wixom Lake during the winter. That's what they wanted. That's what that memo supports. That's what Eagle said no to. They said, no, that's too low. You have other options available. And then Boyce Hydro did it anyway. And so what that means is that that whole dispute about the temporary winter drawdown had nothing to do with the level of Wixom Lake in April or May of 2020. Remember, it's the Spicer Group that asked to return it to that level. They didn't change their story or position. That was still their recommendation. So this is in direct contrast to the Mays case, which I argued. I know what the arguments were there, Your Honor. And in the Mays case, you had engineering reports dating back years telling the city of Flint, you cannot use the Flint River as a water source because it will cause damage to people's health and property unless you invest tens of millions of dollars into the water treatment plant. The state officials who were in charge of the city at that time did it anyway, even though the reports recommended against it with just minimal investment. That was the allegation that carried the day in Mays. Mr. Carlson points out that we argued that the emergency managers weren't state officials. We lost that argument. The court held, yes, they were,
Right.
and they've
No, I
alleged
mean,
that the
clearly
state's
they
in
said
charge.
They were.
So we don't have anything like that here.
Some
There's,
vague recollection of those.
so there's a private,
Not counsel of record in Mays. I was not. I was governor's counsel for a period of time. I had the privilege of serving in that administration well, it was in the administration from January 13th, 2015 until December 19th, 2018, when I was appointed to this bench. But I was legal counsel until about February 16th, now February 20th, 2016. Then I became the director of an agency. So,
well, in Mays, Your Honor, there were these engineering reports telling them not to do it. They did it anyway. I mean, that's basically the allegations.
sorry,
There were engineering reports telling them not to do it. It's dangerous. And they did it anyway. And they were the ones making those decisions. And so that's a very different circumstance in this case.
Do you or Mr. Kuehl know what part of the record is the Spicer application that gives rise to the April 8th, 2020?
Yes, I can tell you. Give me just one moment and I will find it. Um,
That's all right. I don't want to use up your time.
okay, I'm sorry, Your Honor.
No,
But,
no,
but yes,
I
it was-
literally have 10 pages of numbered questions for you and opposing counsel. And I went through this morning to highlight the ones I really needed to ask. So there's a whole bunch of things I'd like to ask, but I'm not going to.
it's
So,
Exhibit 24, Defendant's Exhibit 24.
thank you.
And so the agent for that application is the Spicer Group. And I wanted to put the court's finger on a few references because Mr. Carlson got it wrong. And so I just wanted to give you some record citations. So the first is he said that a 2015 engineering report warned about static liquefaction. It did not. It literally said the opposite of that. So on, this is Defendant's Exhibit, Volume 5, Bates stamp 1134. So Appendix 5, 1134. This is the only reference to a liquefaction analysis, and this was for seismic liquefaction. And it said, quote, "The analysis indicated that the soils of the embankment at the earthquake energy available were not subject to liquefaction, and the embankment soils are not subject to liquefaction." That's what the report said. It didn't warn against it. It said liquefaction isn't a risk here.
What,
That's-
1134?
1134 and 1135. And I don't want to get too far ahead of Your Honor, but I also have another.
Okay, go ahead.
So Mr. Carlson pointed out that the reports highlighted the steepness of the embankment, the looseness of the soil. Well, those are just data points that go into what's called a stability analysis of the embankment. And the 2015 independent consultant did review the stability analyses, and this is on page 1115 of Defendant's Volume 5. And they concluded that based on those stability analyses, they find the project and its facilities suitable for continued safe and reliable operation. So at the time Eagle granted this permit in April 2020, they have a 2015 report saying that the stability analysis shows that these embankments are not dangerous. They have a report from the Spicer Group saying, we think that you should maintain the normal level of this lake and that doing so will not cause harm to private property. And when they go to make a application to get a permit to do so, it's the Spicer Group that makes that application. That is in stark contrast to the case law where a government agency is warned beforehand that doing something is dangerous and will cause a dam to fail. And it, like in Mays or in Peterson, the Peterson case where the DNR was told beforehand, if you build this jetty in this way, it's going to destroy private property, and they did it anyway. That is not at all what happened here.
Let me ask a question. If everybody agrees that for maybe all dams, but earthen dams for sure in Michigan, if everyone were to agree, you have to have 50% capacity for the flow through, you know, the cube, this, I just can't remember the. If you have to have 50% of the probable maximum flood for it to be within regulations, okay, let's call it that. And Edenville's number was 60,000. And apparently there's some evidence of record that it was 28,000 at of capacity. What duty is imposed upon the state agencies when faced with that information? If we agree that, just hypothetically, we agree that they knew it, we agree that the numbers are right. So what happens?
The state agency's responsibility is to contact the dam owner and have the dam owner explain what their plan is to address this deficiency. And that's exactly what happened. There was,
Wait, did Trumbull get a hold of them?
yes.
And-
So,
Okay, what do we learn?
so Spicer Group and the county's task force already had a plan to address this safety problem. They had a construction plan. They were drawing up plans to construct an auxiliary spillway to increase the spillway capacity of the dam. So they were already doing.
Why don't you just lower the level until it's done?
Well, if I can
If you're
point,
the regulator, why don't you say, okay, that's a great plan. You guys are aces all the way around. However, gee whiz, while we're waiting for this,
Your Honor, I can point you to the language in the statute. So the agency can't just decide on its own. That's what we want to do. There has to be some basis for it. So in section, I'll give you a second, sorry.
man, books, sorry. Not only can I not get this, can I not read the screen? I can't get the screen to take me where I want to be. Okay, what's statute, please?
324.31519. 31519.
$315,
Yes.
3115?
324.31519.
315.
It's titled Order to Limit Dam Operations.
Three, two, four?
Yep, 324.31519.
Is it, you sure it's not 3115?
Yes.
324315 does not appear. So, okay, I guess we have to just, all right, let's
Sorry,
dismiss without prejudice. Let's start the whole case over.
No. Well, so Your Honor,
Yeah.
the standard for the agency to issue an order under that section is that significant damage to persons or property is anticipated to occur. And before they can issue an order under sub 3 of that section, they have to provide the owner an opportunity for a hearing under the Administrative Procedure Act. So at that time,
Excuse me.
there was no indication from anyone, including the dam safety engineers that the county's task force had hired, that maintaining the normal level of Wixom Lake was going to cause significant damage, that it would be anticipated to occur. There was no indication of that. And further, there's no indication that, there's no evidence the planners have provided that Boyce Hydro and the county's task force would have just followed that order, that they would not have used their appellate rights, which can take years to work through, and which the law entitles them to. And so in order to meet the inverse condemnation standard, they have to show a substantial cause. And the failure to issue an order, first of all, can't be an affirmative act. It just isn't. And second of all, it's too attenuated. There wasn't a basis for them to issue an order, and there's no reason to think at this point that Boyce Hydro would have actually followed the order, even if they issued it, and it would have taken months to get through that process.
Are you aware of any cases which define what a substantial act is?
Substantial cause, Your Honor?
Yeah, sorry.
Yes, the Peterson case, which we cite to and discuss at length, describes damage that is the natural, basically the predictable, normal, natural. Those are some of the phrases they use to characterize substantial cause. So that's the case where DNR built the jetty.
Oh, right. Yeah.
Everyone said, hey, if you do this, it's going to.
You build it, it's really going to
And
do
they
bad
said-
things to their property.
And they
said, "We
did it
don't care."
anyway.
Yeah.
And so DNR at that time argued, well, we didn't actually go on their private land. And the Supreme Court said, well, you caused it. It was the natural consequence of your decision.
The plaintiffs argued that your client's actions basically resulted in a private taking of a causeway and that your client's actions took the property downstream and made it into, the spillway, as opposed to the engineering plan that Boyce or whomever had come up with, or not Boyce, I'm sorry, Spicer or whomever in Four Lakes had come up with. What do you make of that?
They're just incorrect, Your Honor. That I'm glad that Mr. Carlson brought up the Krieger case, because what the Court of Appeals did is summarize their allegations and said, well, if these are true, it supports a takings claim. But what we found through discovering what plaintiffs has essentially conceded is that it's actually not true. The only thing that they have pointed out, the one thing they have pointed out as an affirmative act that Eagle took, was granting that permit application. That's it. And that alone cannot support an inverse condemnation thing. There's no such thing as regulatory negligence. Doesn't exist. There's no claim for that. The Judge Stevens already dismissed the plaintiff's tort claims back in 2021. So that is not an option here.
Do you agree plaintiff's expert, I think it's Sturdivant, is that the gentleman's name? He's the Colorado, Wisconsin dam guy. And I mean hydroelectric dam. I'm not referring to the gentleman. So he's their dam expert.
Yes.
DAM. I'm gonna have to spell out it every time I say it as we proceed. At any rate, do you disagree with this position categorically? You don't think he may even qualify as an expert, but do you agree that he says a whole lot of things that are in contravention to the position that you take?
He does in his declaration. Yes, he does. And through the course of his deposition, as he identified the sources he relied on, he acknowledged that actually what he previously thought were affirmative actions by the government are not the things that cause the level of Wixom Lake to be at its normal level in the spring of 2020. He had pointed to a November 2019 enforcement notice from Eagle, but he acknowledged under oath, nope, that didn't increase the water level. And then he pointed out,
Excuse me.
he pointed out the denial of the winter drawdown, the temporary winter drawdown permit, and he said that had no impact whatsoever on the water level. So we point out why his testimony does not create a genuine issue of material fact. The plaintiffs do not resurrect that attack. They really don't respond to that effectively in their response brief.
All right. Okay. Thank you.
All right.
I
thank you, Your Honor.
appreciate your position, your arguments. Appreciate those of the plaintiffs. When we take a 10-minute recess and let's for health and comfort break, and then we'll reconvene in 10 minutes. And let's be ready to go into the status conference. Although if I have any other questions or other actions to take on this, I'll let the parties know. Ready? Okay. All right. We're in recess till 11:30. Thank you. Just go about your business.
It's in here now. I
Right.
just want to know if we're stacking up, if we're going to the other room.
No, we're staying here.
Okay.
Yeah, I mean, I sure hope we're not 2 hours together. Not that I don't thoroughly consider it a privilege of the first order to be here with you, but I'm hoping we're not here 2 hours on our status conference. Okay, please go about your business. Thank you.
I was pointing the back. I'll have a discussion.
They flat.
It's like my children.
Feel like Mr. Newman can handle everything
I-
from this point forward.
Mr. Newman, I have this effect on a lot of people.
No, I stuck around. This has been fun. When there's three of you up there, then that becomes a little bit more stressful.
Right. So yesterday, I was visiting. We have 3 kids. They're so amazing. And 2 granddaughters. And I got a text or my phone did something. It's, oh my gosh. So it was my child, who's the parent of my granddaughters, is, oh, just called because so-and-so wanted to say hi. I'm like, oh man, I get it. So I leave my chambers, which are downstairs, because the coverage isn't that great. And I go out in the waiting area, the public area above the top of the escalator. So we finally connect and having this nice visit. And then I say to my grandchild, hey, do you want to see where grandpa works? Oh, wait, yeah. So she's 3. So I do then I do the video, not looking at me. I said, okay, well, this is where we go in and ooh, yeah. And then I came in and all the lights were off. I started turning the lights on and said, I go, well, this is tomorrow. Grandpa's going to be sitting up here. And she, oh, Grandpa Cumbo, who's her, no, that's no, Grandpa Cumbo. He's a doctor. He's helping other people. No, Grandpa Redford will be, talking with people. I go, okay. Anyway, it was fun. So the technology, anyhow. All right. Thanks for the arguments on the motions. I'm gonna tomorrow. Today is May 5th. On May 7th, gosh, 7 days from now, on May 12th at 3:30 in the afternoon, I'm gonna indicate my opinion on the record by Zoom, so nobody has to come back. I'll probably be. I don't know how to do it from my chambers, so I'll probably be here in court. But we'll use the same technology that our IT is utilizing to, link everybody in today. It'll, I guess, technically be on the record. Well, it's not technically, it definitely will be on the record. So the courtroom will probably be open. I'm not going to be taking any additional argument, but I would anticipate, unless you get something from me between now and the end of the week, that at 3:30 next week, we'll be back and I'll be, making a decision on the motion. It would just indicate, uh, this first part of May is very busy for a lot of judges. We have a state judicial conference in Detroit starting Wednesday. Next Tuesday, I have case call in Detroit for 2 days and then 2.5 days or then another 2 days of the Michigan Appellate Bench and Bar Conference, which happens every 3 years. So I would like to have been able to do an opinion right now, but the arguments were very thought provoking and I need to do some more work before I'm prepared to put my opinion on the record. It'll be an oral opinion. And I will have an order saying basically, for the reasons stated on the record in open court, the court rules, blah. So whoever's going to file the emergency appeal, you're going to have to get a transcript. So anyway, so that's sort of for next week's time together, just for planning purposes. Now we move into the next stage. Mr. Trudell, you still okay?
Also,
All right. So the lawyers are going to be talking. I'm going to ask them to identify themselves. Mr. Trudell, we do now have microphones at each of the council table. But if any time when we're discussing things, you don't know who's talking or you don't know what they're saying, if you would be kind enough to interrupt us, I would be very grateful. And I'm sure the lawyers would too, since we need to have a complete record of our proceedings. Any questions?
nope, thank
All
you.
right. All right. Thank you, Mr. Trudell. Okay. All right. Plaintiffs have the burden of proof. You get to go first.
Your Honor, David Dubin, speaking on behalf of the plaintiffs.
Okay.
We submitted our agenda. I guess there is some couple issues that, Mr. Gamble and I, and also on the road that Mr. Cole, have agreed to. First, and I appreciate you offering the courtroom at the end of this month. However, we have resolved the issue relating to Mr. Williams. And the issue of 670, he will be issuing a rebuttal report, and approximately by this week, and then the state after reviewing it will schedule his deposition at a good date time. We have no objection to that process. So we will not aid your wonderful courtroom facilities. And as I said, I appreciate them.
Okay.
The second issue that was raised by our agenda.
Here's the rub though. I'm going to let the lawyers try the case the way and prepare the case for trial if it continues in that journey in that direction, in the manner in which they believe is most appropriate from their perspective, their professional experience. But what I do not want to have happen is we proceed in the fashion you're suggesting, Mr. Dubin, and I appreciate that the people's attorneys have agreed to do that as well, or the department's attorneys. I don't want to be reading in some motion filed by some party, well, we were there and then we stopped. And so now you got to figure this out. I got news for everybody. That is not going to be a positive experience for anyone if that becomes necessary. I understand, having been a litigator on both sides of the V, civil and criminal, having been a trial judge for 12 years, 5 years as well in the military on a reserve basis. Sometimes judicial officers have to get involved in discovery matters. We have assuming the case continues, we have a very compressed schedule. And we have a lot that has to get done. And between now and then, I have Court of Appeals case call every month. So I have 20 appellate cases I have to prepare for, a third of which I'm the assigned principal writer on. In addition to that, I have a 2-week trial that's scheduled in December involving numbers that have many zeros. We will finish that December trial, and 2 weeks later, I will be beginning this trial. In my world, that's tomorrow. So if we have discovery problems, I will tell you now how I handled it as a circuit judge. If I have motions to compel, if I have motions to strike, as soon as I get them, I start keeping track of how much time I am putting into it. And I keep track of it by the 10th of the hour because I know how to do that. And I will go through it. And if the lawyers can't resolve their discovery issues, the party that loses will be paying the cost to the people of the state of Michigan to have a court of claims judge spend an hour, 2 hours, 5 hours. And it's not $200 an hour, ladies and gentlemen. It's what does this brick and mortar cost? It's what are the other things that can't be done for the people of the state of Michigan because I'm working on a discovery dispute that shouldn't have had to happen. I can tell you every year when I was a circuit judge at Kent County, I got our annual budget, I divided it out, and it basically, for the 12 years I was there, it went from $2,500 to $3,200 an hour. If it takes 2 hours, the party that loses, if it's $2,000 an hour, you're sending a check for $4,000 to the Court of Claims in the state of Michigan. I'm not saying that because I think there will be problems, but I don't want there to be a surprise. And I want, when the Court of Appeals is reviewing my decisions for an abuse of discretion, I want them to understand, I advised the parties ahead of time. We talked about this. I offered our courtroom and our facilities for 6 solid days to be able to resolve this immediately, and it wasn't resolved. So I'm fine with that. That's great. Let's hope there's not problems. I don't think I affirmatively think there should not be, but if there are, it can get complicated. And I will say, I've had one case where one lawyer was, well, suffice it to say, the lawyer was going to be paying the attorney's fees for every lawyer for 2 days while we waited for his client to come from a place that was very far away on whatever their blended hourly rate was going to be. So I've done it before. I've never been overturned on any ruling that dealt with discovery problems. There's a first for everything. And this case has many firsts for me. So maybe this will be the one where I'm educated well by my colleagues on the Court of Appeals. And again, I'm not trying to be mean or nasty. People sometimes say Redford has a judicial temperament issue. Well, so be it. I am direct, and I want people to understand what my expectations are. So with that, happy coaching. What else do we have, Mr. Dubin?
The other aspect is Ms. Greiner's PMF package models that we identified in our agenda. They have been produced in their unaltered state. The last discovery issue was the PAC HMS model that.
Can I interrupt 1 second, Mr. Dubin? What was the name of the first witness we talked about? Ms.
Greiner?
No, the one before that, before I went on my diatribe.
Oh, Mr. Williams.
Thank you.
I was enthralled by your diatribe that I forgot completely.
You all know I come from a real big family, and just trying to get a point in at the dinner table was often harder than getting served. So it's anyway.
The last remaining discovery issue that Ms. Gamble and I discussed prior to you taking the bench was the altered model of Mr. Williams that was altered by Mr. Trumbull, where he changed the starting elevation according to his deposition to 670 and ran that model and both other scenarios. Mr. Gamble certainly will express his opinion. That was not part of his opinion. However, those model runs would be subject to the first request for production of documents. While yes, he took Mr. Williams' model, he has modified it with inputs, and we think it is relevant to this discussion.
Okay.
The other part of it is dealing with the privilege log. I will turn this off. She'd like to continue on this.
Oh, let's tee up whatever you have and then we'll go to the other side of the V and find out what the defendant's position is.
Privilege law, we had a discussion with Mr. Gamble, part of our bi-weekly sessions that we have. And he indicated that he'll provide us with a response, I believe, in this week. So,
What does that mean?
he's supposed to respond to the issues that we raised where, there were redactions without proper privilege.
Okay.
And as far as addressing the specifics of that, till we have the response, then hopefully we can work out the items to get the response.
Okay, thank you. 1 second. Anything else from plaintiffs?
Else.
All right, Mr. Campbell, Mr. Kiel.
Nathan Gamble on behalf of defendants. Thank you, Your Honor. As plaintiff's counsel noted, we actually met twice and have discussed the matters raised in the status conference filings and virtually got all of them resolved already, at least between the parties. The one outstanding issue, as Mr. Dubin mentioned, was Luke Trumbull's information. Our position is very clearly stated in the status conference filings.
Why do you? Okay, what is it that they seek that you think you shouldn't have to and or are not required to provide?
They're asking for information they already have. So they're asking for Mr. Trumbull to provide Mr. Williams' model back to him, with the one exception being the modification Mr. Trumbull made to the model, which Mr. Williams has already done himself. So they're asking for information they already have. That was not the basis of any of Mr. Trumbull's expert opinions. However, Your Honor, I should just say, even though I think this is an unprincipled request for information we don't agree with, rather than continue to fight about it, we're fine just sending it to them. And so from our perspective, this is resolved, even though I think it's
You, as often do, Mr. Gamble, in these last, 14 or 15 months, we have walked this journey together. You've read my mind. So, because the question is going to be, if they've already got it, Mr. Gamble, why are we? Okay, perfect. Great answer. When might you be able to do that, do you think?
I have to talk to Mr. Trumbull. I'm honestly not sure, but within the next couple of weeks, I'm sure.
Okay,
Assuming he still has this information, so.
okay. Mr. Dubin,
I think that would work here. I appreciate you.
thank you. I appreciate everybody's efforts. You got, every lawyer in this case is undoubtedly working harder than I am on this case. So I appreciate your efforts on the plaintiffs and the defendants as well. So these are, I appreciate everybody's hard work. Thank you. Okay. What else we got?
For us, we don't have anything else, Your Honor.
Okay. All right. I read with interest the submissions about the privilege log. I read with greater interest the submissions about the privilege log when I cross-referenced them to the attachments to the pleadings. This court has issued 3 previous opinions that relate to privilege logs. in my service as a court of claims judge. I should say two previous opinions. One is about to be issued. Everybody who has a P number to practice law in this state or another state who's present in this courtroom, and probably Mr. Cranmer, our security, who is a former captain in a police department here in West Michigan serving the public, we have all had to deal with privilege logs as litigators, as witnesses, as individuals who provide information, and as judges. And I read the privilege logs that the defense submitted, and I'm not ruling on them. But in previous cases, privilege logs that looked a whole lot like this, I found completely satisfactory. So I don't know exactly what you need. You know, there's discussions of, well, we got to know who it was sent to. Okay, I mean, that's, yeah, I can get that. But I mean, if I were a plaintiff's counsel or a defense counsel and another side asked for a memo I sent to my client, I mean, of course I wouldn't give it. It's either work product, attorney-client privilege. The attorney-client privilege is one of the oldest privileges recognized in the common law of the United States. It predated our status as a nation. That and the priest-penitent privilege, I think, are the oldest privileges. So I try to work it out. I'll decide it if I am required to. But I think when I look at privilege log disputes, I think to myself, whether I'm the defense counsel, the plaintiff's counsel, or the trial judge who has to call the balls and strikes on it, what does success look like? And for the trial judge, success is always the case is done, and it goes to another court to decide whether to affirm or to reverse. And if reversal, all trial judges in their heart of hearts always ask, if I'm going to be reversed, let the reversal be clear with direction so I can avoid the mistakes that you found that I made the first time. That's all I ask. I don't mind being reversed. I didn't get reversed very often as a trial court. 27 times out of 10,000 cases. But when they came back, it usually had pretty clear. There were a couple that was like, I don't know, I'm not sure what to do. But those were the exceptions. So that's what the trial court wants. As a litigator, what is success for the greater information I need in the privilege log if I'm plaintiff's counsel? Is it that I'm going to get more documents? Is it going to get opinions? I'm going to recover a smoking gun? I don't know. And defense on why I'm asserting the privilege log, is this necessary to, given the broad scope of discovery in the state of Michigan, in the state courts, should we be, is this worth fighting? Or is it ultimately going to be required to be produced? So I know you're thinking of those things, and I'm not telling anybody something you haven't already thought of 100 times in this, but just, I used to tell the civil litigators at the beginning of a complex case, we're going to go through a year to 2 years of discovery. Right now, at the beginning of the case, both sides know 90 to 95% of what you will ever know about this case before the complaint's filed or before the answer is drafted. You already know that. You will never know 100%. It's impossible. You'll never know everything. So what level of energy are we going to spend and resources of our clients and of the people to obtain the remaining, if it's 90% that you know, 9%, 8% that you're going to find out? And is that 9 or 8% additional amount of data and information material enough that it justifies the expenditure. I don't know. Sometimes it is. I would say, in my experience, very rarely, but well, I guess once in a while. At any rate, parties have expended hundreds of thousands, almost certainly millions of dollars in the prosecution of these claims and in defense of them. Very capable lawyers have litigated this case. I suspect capable lawyers have litigated the previous cases involving the subject matter giving rise to these actions. So we just need to move forward, and either we'll find out next Monday whether the case continues. If it does, then we need to move forward towards our next steps. End of sermon. So sorry. All right. For planning purposes, assuming the case goes to trial, how many days is the plaintiff's case going to take to put in?
What would be the days of trial? I mean, do you-
What is a trial day? Yes, that's a very good question. Thank you. That's a great question. Okay, so if this case is scheduled for trial, you're going to get a multi-page scheduling order. In quick response to your question, Ms. Almanroad, a trial will start at 8:30 sharp. We will go until noon with a 15-minute recess sometime in the morning. We will have a 60-minute recess at noon. We will reconvene at 1 o'clock, and we will go until 4:30 with a 10-minute recess sometime in the midst of the afternoon. That will begin see if I can work.
Is it January 12th, Your Honor? I'm looking at the February 10th.
Yep, that's what I'm seeing too. Yeah, so we would begin trial January 12th. We will try the case 5 days a week until it is completed, with the proviso that in the first week of February, if we're still going, which I don't think we should have to be, but if we are, there will likely be at least a 2-day recess so the Court of Appeals of the State of Michigan can hear oral argument in the Grand Rapids district. I will tell you right now, I'm going to be asking the Chief Judge of the Court of Appeals to limit oral arguments in Grand Rapids to 1 week instead of 2 weeks in both December 2025 and January. Yeah, we're in 2025. Yeah, and January 2026. So in February, yeah, February as well. I don't know how that's going to be received and what anyway, that's internal court business. But normally we have 2 weeks of oral arguments each month in each of our courtrooms. Detroit, Grand Rapids, and Lansing. I'm going to ask our chief judge if we can, and they know this case is coming, and they know my December case is coming too. So we're all trying to make, but the actual trial day, that's basically what we're looking at. In this court order, trial scheduling order, you are going to be advised of what I require as far as exhibits. You will be required to meet and confer regarding all exhibits. You will then present to the court, probably a month ahead of trial, all of the exhibits that are agreed to. And I think that's going to be probably 75% of the exhibits in this case, might be a little higher, a little lower. Then there's going to be, and you're going to have a, a, a chart which says, you know, what the exhibit number is going to be on it, who's offering it, who the witness is, and a like 3-word summary of what the thing is. You're going to provide 5 printed copies in 3-inch binders to the court or 3 sets of copies in actual physical format, and you're going to provide digital copies as well. For the exhibits that you cannot agree on, the plaintiffs will provide their set of exhibits they can't agree on, and the defendants will do the same. If we are in trial and you are seeking to introduce an exhibit which is in not one of those 3 binders, exceptionally good cause will have to be demonstrated. I find it extraordinarily hard to imagine such a document that is not in existence and in possession of the parties at this time. So I get that there could be something that could come up. I had it in a medical malpractice case years ago that a certain film study wasn't disclosed. That's a horse of different color. But, you know, and it's something that the event took place 5 years ago this month. I imagine everything's out there. So you'll have that. You'll have an order for how long, when trial briefs are due, witness list, you know, all that stuff, whether we're doing debene essay or live witness testimony, you know, things along those lines. And I've got very experienced trial lawyers in this case. If when you get the trial order, you think, oh, I think Redford's kind of off on this one. Okay, talk to opposing counsel, see if you can come up with what you disagree or what you think I'm wrong on, and then bring it to my attention through, you know, either get a phone call set up with Ruth, you know, we do a status conference, we change it. That is not going to be coming out. That trial order, that's sort of what it looks like. I have issued trial scheduling orders in previous cases. I can't tell you what case number to look at, but you know, it's generally that's the genre we're talking about. Does that answer your question? So how many days are you going to need? Okay. What about the defense?
Also probably 2 weeks, Your Honor, though we're pretty efficient, so we might be less.
And I will, good. Okay. Okay. I will say it has been my experience. I had, I think 234 jury trials as a circuit judge. And 50 matters, some went to trial, some were settled as a military judge. I don't have a memory of a lawyer ever saying, boy, this took a lot longer than I thought. And the reason is, no kidding, we started 8:30, witness ready. You know, 8:30 doesn't mean you're coming in the courtroom. And it doesn't mean I'm coming in the building. It means, and obviously, if you have an emergency, if somebody's child is sick, if somebody's grandchild is sick, if your dog needs to go to the emergency vet, yeah, we're going to be reasonable, within reason. Okay. But we can get a whole lot of testimony and proofs in the trial day that I indicate. We'll be, you know, we'll take health and comfort breaks. If somebody needs to use the restroom, we're going to take a break. If we have an expert that if we go another 20 minutes at the noon hour, that expert can then get on the plane and the parties who retained them can save $2,000 by finishing it that way. We're going to do that. I mean, if we, you know, same, if we get to 4:30 and if we can finish up an expert and we can get them, experts are great, but experts are expensive. If we can get the expert back to their home and the clock stops running for whoever it is that brought them, whether it's the state or the plaintiffs, we're gonna push on. I can tell you, I have literally tried trials at sea starting at 1 o'clock in the morning. So I am fine going long hours. I'm not dying to, and I don't want to die trying it. So, and I'm a whole lot older than I was when I was a Navy JAG out in the fleet in the Mediterranean and the Persian Gulf and the North Atlantic. So, but, we can get this done. So the numbers that you talk about, 2 weeks on both sides, are not unreasonable. My guess is it'll be shorter than that. My guess is that plaintiffs would, if we start on Monday, the following Monday is the Dr. King holiday, so that'll be a 4-day week. My guess would be the plaintiffs will be done close of the business day, Wednesday or Thursday. So we also just need, when you're thinking about this and you're talking with your witnesses and your experts, I don't. We just need people ready to go. We need them ready. And AG's got an office here. There are a bunch of law firms involved that have offices here in Grand Rapids. Are plaintiffs going to want to have like a trial litigation conference room in this building if possible? Or do you want to have, okay, we'll start working with our team on that. And Judge Yates has a trial starting July 14th here in this courtroom. So he's going to be the first trial in this courtroom in the Court of Claims. So we've got our staff coming in on the 19th, 18th or 19th, people from Lansing, IT, to make sure. Here's what I'm expecting from logistics. Do the defendants, since there are less lawyers on your side, are you going to need more than one table? No. How many tables are plaintiffs going to need? Okay, so Dan was in here when I was playing interior decorator, and if you want to see how I design stuff really nice, I got to show you my deer blinds, but they're not that. No, in all seriousness, we can move. There's a 8-foot distance between these tables or thereabouts. And I think these tables are 3 foot by 7. Did we say, Dan? Something like that. I think we're going to probably move over a little bit. We're not going to put defendants all the way next to the wall, but I would imagine defendant's table will be maybe 2 or 3, probably 2 feet further over. The witness table is going to have to be down in the well of the court where I can still see them because I'm the trier of fact. I would expect we would then, and we're trying to get, we have our budget people and our IT people coming in on the 18th or 19th. Your main plaintiff's table is going to move over a little bit. And then probably one more table there. And what I thought, because the chairs in the gallery can be moved, I was thinking one more plaintiff's counsel table behind the bar. Maybe we scooch it up right next to the bar, but that gives, that's what I was thinking. And we have, 2 or 4 seats at that table. I don't know if we probably don't have that one mic'd. But anyway, that's sort of logistically what I was thinking that we would probably need. Does anybody have any, it would be helpful if you thought differently, let me know now, because like I say, I'm meeting with these folks in 2 weeks. Okay. Okay. Yeah. All right. And then, obviously, would plaintiffs expect most of your experts are going to be live or Debeni essay? Okay. Defense as well. Okay. I mean, we've all been in cases where they've been Debeni essay, and it's, every fact finder pays attention. It's a little easier to pay attention when they're actually in front of you. So, but it's up to you all. I'm not going to tell somebody how to try their case other than lawyers that I'm related to. So I don't tell them frequently. So, okay. So 2 and 2, 4 weeks. So anyway, my guess is we'll probably get it done in 3 weeks, but I'll block out 4. Okay. I can tell you, I've never had a trial that went, well, I was in a trial that lasted 8 weeks, but we were 8 weeks on the calendar, 7 weeks in trial. That was a long trial. So anyway, those are some of my thoughts. What else should we be talking about before we say farewell for the day from plaintiff's perspective?
Following up on your trial protocol, what are you envisioning for opening statements? You know a lot about the case.
Right. I mean, yeah, let's have mercy on one another. I mean, if you can't give Mr. Gamble's opening statement, and if he can't give your opening statement, I'd be astonished. So I actually did think about opening statements yesterday. Let me think about it. It is very helpful. I'm not going to require it, but it's very helpful to get a trial brief. When I was an assistant U.S. attorney, those were our Rosetta Stones. That's what, it really is helpful. And also, think in terms of if we go to trial, what are your proposed, I'm going to be asking for each party's proposed findings of fact, proposed findings of law. I can tell you as a trial judge, when I gave jury instructions, every member of the jury had a printed copy individually of the opening instructions. We retrieved those after openings, and then every juror had a written copy of the final instructions, 100%. And it's no great idea I came up with, but Judges McKeague and Judge Enslin both did it that way. And I thought it was so helpful as a litigator to say, look at page 14 of the judge's instruction. This is where the defense fails or the government fails. That's what my friends would say when I was prosecutor. Here's where I would, whatever. So having that resource was, I think, helpful for the juries I had the privilege of presiding over the trials with. And again, the trial briefs, I think are a really, believe me, trial briefs are going to be limited. I was thinking yesterday, how long? 20, no more than 50 pages, and probably 25. Maybe I'll make them 50, but trial briefs are helpful. But as far as opening statements, counsel, I was thinking about it, and I'm not sure I'm going to need them, assuming that the case continues. But I also never want to. I think it's important. I think it's helpful for clients to hear an opening statement. I think it enhances confidence in the system. So our system of justice, not system, but I'll think about it. And I welcome whatever your thoughts are too. If the lawyers think, hey, we've been through this for 2 years, Judge, at that point, it'll be 2 full years that we've been on this journey together. And if I don't know what your claims are by then we got, then I should be in front of the Judicial Tenure Commission because I can't do my job. But I'll welcome your thoughts. We're going to have other status conferences, and I think we have one scheduled in August sometime. Okay, what else? Anything else from, yes, ma'am, Ms. Almanrod?
I don't think all my clients will start to understand it.
Oh, I can't imagine that I've never ordered a plaintiff to show in a civil case.
No, we're not going to require 2,000 plaintiffs to attend, or we're not going to
They
ask
need
the
a change of
court.
venue.
Yeah.
No, but I hope, I'm assuming we're going to be live streamed. So any interested party is going to be able to see what's going on for the entirety of the case. That I think is very important. From I believe, I think they should be able to weigh and measure who the lawyers are, weigh and measure for both plaintiff and defense. They can weigh and measure the trial court. Think, oh my gosh, this, whatever. So yeah, but no, I would not envision anybody being compelled to come. It's a civil case. They're not required to. If it were a criminal case, they would be required to come here. But it's not. It's civil. So anything else? Anybody over there? All right.
Nothing from the defendants, Your Honor.
All right. Then I'll look forward. Again, it's a privilege to serve on the Michigan Court of Claims. It's a privilege to serve on the Court of Appeals. It's a privilege to serve each of the lawyers in this case. I'm very grateful for their zealous advocacy on behalf of their clients. It acquits themselves well and our system of jurisprudence well. So well done all. On a week from today, plus 2 hours and 3 hours and 15 minutes, we'll be back on the record by Zoom, or anyone, I guess, can be here in person if they wish to. Not required at all. And I know I previously said Ms. Omenrod and Mr. Gamble have to be here. There's an asterisk. There's a waiver. You don't have to be here next week. So, but anyway. All right. Without anything further, let me just ask Scusa, anything else I need? All right. Thank you so much, everyone. I hope everybody has a pleasant day. Court's in recess. Please go about your business. Thank you. Thanks. Thanks, Mr. Trell.
Thank you.
Those microphones work okay?